Good morning. It looks like we're ready to go on the record any moment. Judge Dorow is just taken to the bench, but I haven't heard him say anything yet. Let's see. Oop. And Aowen is purring up a storm if you can hear her. Let's see. I saw a thing that Chad Daybell thinks that he doesn't deserve the death penalty because he's less culpable than Lori is.
Son.
Oh.
Me. Well, actually, I have the printed copy, so I'm okay.
Chad doesn't seem to know that if you're a conspirator, you get the equal punishment. I'm not sure that he is less culpable. And there's some evidence to suggest that Chad was the one who actually killed JJ.
Oh, I forgot to put this back in Judge Bowman's office. In where? In Judge Bowman's office. No, there was some here. It's a statute book, a big old statute book.
Got it. Okay, got it. Oh, okay. I did that. You're good. I'm just gonna clean up the coffee when we get. Yeah, good.
If you're looking for Judge Domino, he's up a floor. Yep, he's in 1016. This is 13. Yep, one floor. Not that you couldn't color that, but I just figured I know where she's going.
Things seem to be a little less formal today because it's just a jury conference. Yeah, and no actual
They're what?
evidence today, and they haven't officially gone on the record yet, which seems a little odd, but we're missing our lead defense attorney. Wonder where she is. It's probably why they haven't started. Oh, here she comes. Okay, maybe we'll get started now she's here.
Oh, I have the stapler. It's closer to me than you.
Well, she's wearing black. She knows she needs to go into mourning for her the rest of her life.
All right. All right, we will go on the record then. Good morning, everyone. The court is calling State of Wisconsin versus Jessy Kurczewski, case 21 CF 885. May have the appearances, please.
Good morning, Judge Randy Sitzberger, Abby Nicolai, and JJ Crawford for the state.
Donna Kukler, Pablo Galvez appear with Ms. Kurczewski. Good morning.
All right, good morning. We are here this morning to conduct the jury instruction conference. As the parties should be well aware by now, the court worked on a draft of the jury instructions until almost 6:30 last night. Madam Clerk emailed those to the parties. There are some questions in there from the court as well. I highlighted a couple of things. And of course, we also have the request and the motion from the defense for a lesser included instruction on assisted suicide. And then Attorney Galvez, I believe, emailed everyone, and then Madam Clerk printed it off for me, a request for a special jury instruction as it relates to count 3. First of all, has the state had an opportunity to review the draft that the court sent yesterday?
Yes, Judge, I have.
All right. And how about the defense?
I have.
I'd like to at least get through the issues that are not contested. And we'll just page through this. And then if there are things that are contested, I'll just put an asterisk and then we'll circle back to those. Starting with page 1. This is the standard introductory type language. Then it goes into the 3 counts. The court, simply based on a request prior to trial with a question, is this being requested, also included the bridging instruction. A different version of first degree intentional homicide that had a bridging instruction with first degree reckless homicide. So I don't know if the defense is requesting that at all. Is there a request by the defense for that?
No request for reckless.
No request for reckless?
Well, I mean, not at this point.
You need to tell me now. I'm not piecemealing this. So if you're saying, because what I hear you say is, well, no request now, but if I deny your request for assisted suicide, we're going to request it. So you need to tell me now what the requests are.
Just one moment. Let me
Sure.
Talk this over for a minute.
Thanks, Ryan. Okay. Thanks.
Well, certainly if she knew that if indeed she Lynn wanted to commit suicide, she certainly facilitated it by by buying all of those eye drops instead of saying, no, I'm not going to do it.
I think it should be all, you know, if you want to hang out, you can too. You can have a seat next to Teresa in case. I don't know, do you have a laptop?
I do. I'll grab it.
Yeah, go grab it and come back. That'll be good.
But I don't think that Lynn was suicidal. I think that after learning that the eye drops are used to facilitate sexual assaults in bars and clubs and things like that, that they were using it on a regular basis to make Lynn compliant to sign checks and hand over money and so forth to get her money. And when the money ran out, there was no reason to keep Lynn alive. He was an inconvenience, just as the cat was an inconvenience. And as soon as Lynn was down, they put the cat down. You know, same mentality. Seems a little funny that the attorney is holding up the paper to block her face, because I don't think they can really read lips from the side.
All right, Attorney Kukler, is there a request for a lesser included of reckless homicide?
I just have a question for the court. If I say yes to that, that doesn't preclude you're not going to take that into consideration, are you? And preclude, I'm not saying you're agreeing to an assisted suicide, but by agreeing to a reckless, that doesn't preclude us from having a third option of assisted suicide.
I just want to know if there's a request from the defense, because this was raised prior to the start of the trial, where the defense asked that I instruct preliminarily on reckless homicide. I think the case law tells me that to primarily consider lesser includeds upon request. So really my question is, are you maintaining that request or no longer requesting the court consider a lesser included of reckless homicide? I understand there's trial strategies involved, and I don't in any way want to interfere with that. I just don't want to piecemeal this going forward.
Right, but from my perspective, from the defense perspective, I think I'm requesting that we come back to this decision depending on how the court rules on the assisted suicide, because you can't piecemeal it. And asking me to give an answer on the first on the reckless at this moment, when we don't have your decision on the assisted suicide, feels piecemeal in a way. And so I'm asking whether or not we could deal with the assisted suicide, and then we could make a decision on the reckless. I'm not sure why we need to do it in the order that you're suggesting. Makes it very
I'm
difficult.
just simply asking if there's going to be a request from the defense related to reckless homicide and whether this court should consider it as a lesser included offense.
Well, I will say this. If the court denies the request for assisted suicide, we would request the reckless. If the court agrees on the assisted suicide, we would not want the reckless.
State have a position on that?
I'm fine circling back to it, I guess, if we need to, if that's a cleaner way of handling it.
Okay, so I'll put an asterisk on that. Anything about the language of the first degree intentional homicide jury instruction that is included on page 2.
I didn't see anything wrong with it, Judge.
Nor did I.
Okay, we'll just for now skip over pages 3 through 8 because that is a different version of the intentional homicide with a bridging instruction and reckless homicide. Then the second count, which starts on page 9. Any issues on page 9 from the state,
Not that I saw, Judge.
from the defense?
Agree.
Same thing, page 10.
On page 10, just under sort of the middle of the page, under the third count, it has, oh, I'm sorry. I thought it looks all right. Sorry.
You know, the defense has submitted some special jury instruction, but I'm not clear as to the basis for the request legally and where practically in the instruction the defense is making this request. I don't necessarily want to argue this at the moment. I just kind of want to know where you saw it fitting in.
Attorney Galaviz drafted that, but I believe that he would, maybe he should speak to that, but I believe he wanted it under element 1 as a definition. Go ahead, you can speak to that.
That's correct, Judge. As far as defining property of another, I was hoping to, well, I was requesting that the court place the language in the special jury instruction in that location, defining what is property of another.
All right, so I'll make a note on that. We'll circle back to have a more full discussion on that. But other than that, would the language on pages 9, 10, and 11 as it relates to count 3 be approved?
Yes, from the state.
Yes.
All right, then information on evidence is pretty standard. Burden of proof, as you can see, just based on a comment that was made by the state off the record, you weren't going to take a position. That might have been on the record, I'm not sure. I highlighted the word must. Is the state still not taking a position on that?
I don't object to how it appears on page 12.
All right, and is that the request from the defense?
It is, Your Honor. Thank you.
All right. And I only changed that one word. That's my understanding, is that proposed 140 that'll take effect in January only did that. Is that your understanding, Attorney Kukler?
It is correct. That's correct.
And that's your understanding as well, Attorney Sitzberger?
Yes, and I did compare the two word for word, even the comments yesterday. That's the only change, is that one word.
I did the same.
Excellent. Okay. Evidence defined. That's standard. Any objection to that?
No, Your Honor.
No, Your Honor.
All right, then I put together the agreed facts instruction based upon my memory of what was discussed. And that is literally just that 2 paragraphs on page 13. I reworded a little bit just because I thought it read a little bit better, but I'll hear from the parties on that one from the state,
I have no objection to how it reads.
from the defense.
It reads well.
All right, so you approve.
I approve.
Thank you. Then going on to page 14, we have circumstantial evidence, motive, and the start of credibility of witnesses, just as the first 2. Any objection?
No.
No.
Credibility of witnesses. Any objection to that from the state
No.
defense?
No.
Then going on to page 15 at the very bottom, impeachment of witness prior conviction, and goes on to page 16. Any issue with that from the state,
No objection.
from the defense?
No objection.
All right, then the court drafted the next one. It is a cautionary instruction based upon evidence of other conduct. The first question would be, is the defense making any request for cautionary instruction regarding the other acts evidence that was presented?
Yes.
All right. And then I drafted this pretty generally. Do you take any issue with any of the verbiage or have any suggestions for the court?
So no, the verbiage is good. The only thing I would ask is that when these go back to the jury, that there's a bit of bolding.
Oh, that's just my highlights. So when you saw it electronically, you knew that those were questions I had for the parties. That will, of course, be taken out.
Okay. So
As you approve it, I'm taking the highlights.
oh, okay, great. Because even when I printed it, it showed up. So, okay.
Yeah, no, I just wanted to sort of direct you to things that I thought warranted a further discussion. Those will absolutely be taken out.
I think Attorney Galaviz just pointed out that the only thing we would ask for on that is that we add the year 2010.
For both, I gotta look at
They were both in
They were-
2010.
okay.
They were both were.
that. So looking at where it says specifically, comma, evidence has been presented that in 2010, you would ask me to add that?
Yes.
Any objection?
No, Your Honor.
How about from the state?
The only issue I saw is that the court has listed issues of motive, intent, and absence of mistake. And I think when we looked back at the transcript in meeting with the defense to talk about jury instructions, I believe the court's order for other acts was for motive, opportunity, and absence of mistake. I don't think it's the biggest deal in the world, but just to keep the verbiage the same across court decisions.
I was going off of memory and then I realized I had the transcript and I unfortunately kind of ran out of time looking at it. What's the defense position? Do you recall the court also indicating it was permissible as to opportunity
Yes, I think a not intent.
and not intent?
Right. I think it was motive, opportunity, and absence of mistake. Am I right about?
I'm sorry, there was also context and background as a permissible purpose.
So I, now having heard the testimony, it was very small in comparison, right, with the evidence on the case as a whole. I don't know that it really goes to context anymore.
That's fine. I was just trying to make sure
Or
that
back, you know, and I would also say that as to background, because it's been utilized from my perspective, and the state can correct me if I'm wrong, as to this motive, intent, and absence of mistake or accident. I'm not sure it even applies to opportunity at this point, just given, but I'll hear you on that if you want me to include it.
I guess I don't know what it would look like taking out the intent. So further below under definitions, I'm not sure, and I'd have to look at what opportunity would read there. I'm not asking the court to include anything on context and background. I think that gets very confusing when you then tell the jury they can't use it as far as conformity and things like that. So I really only brought that up to complete the record from the court's decision.
I think intent is appropriate. But I have to look at the transcript if I included that, but
In looking at 275, opportunity would read, quote, opportunity, comma, that is, comma, whether the defendant had the opportunity to commit the offense charged.
and these would be the theft charges. So I'm not sure, especially given count 3 is from an estate. So I think that it distinguishes it. I think it's cleaner just to include these, but
To be fair, I'm fine with how it reads on page 16 into 17. So I'm fine leaving it as is. I just wanted to make sure we were all aware that the original decision had slightly different language.
what's the defense thought on that? Just keeping it as is, changing it in any way, given my earlier decision?
Right. I as we're talking about it, I just don't have the transcript in front of me, but I didn't recall the court saying that it was going to come in on intent. That's the only question I have at this moment. And I apologize, I don't have transcript along with me. today.
I know I had a long discussion, not long, but a discussion about intent, its relationship to motive. Opportunity, motive. I know initially I talked about motive. Let me just get to that part. The purpose of motive, opportunity. So, no, not in the right spot. I said they were compelling, but then I went through an analysis of intent. And if I didn't state it specifically, I was specifically referencing that as a permissible purpose. And so, and given the testimony that the court heard, I think it's appropriate to include motive, intent, absence of mistake or accident, and then leave out the context and background and even opportunity. So I'll revise that ruling based upon the evidence that actually came in and the permissible purposes that are available to the court, my prior ruling, and again, kind of tweaking it based upon the evidence that was actually received at trial. So that part will remain as is. All right, then page 17, statement of defendant. Statements, it says plural. This is a standard instruction. Any objection from the defense to that?
Well, I'm sorry, just going back on page 16 though, paragraph 2, specifically evidence has been presented that in 2010, you're going to add the defendant, it should say attempted to obtain a car title loan. She didn't actually obtain it.
State agree with that?
Yes.
Okay, thank you for that clarification.
I'm gonna share it just so you can see.
It's okay, we'll just do it. Attempted to obtain a car title loan at a payday lending store by using someone else's personal identifying information and attempted to open a savings account in the name of another person. All right, thank you. All those corrections and changes will be made. And then going on to page 17, any objection to that from the state?
No.
From the defense, this is specifically statements of defendant?
No, we asked for that.
All right, so moving on to page 18. So this is the defendant elects not to testify. I included some of the cautionary language from other things that came up. Not sure what the parties' positions are in terms of location, content, and any type of heading, but this is where I included about hearing testimony and seeing evidence about the defendant being in custody, that's not to be considered. It must not influence your verdict. I struggle with that a bit because I know some of the evidence and perhaps argument I think ultimately that will be made is that one particular document, that second will, was sent while she was in custody. So I don't want to mistakenly tell the jury that her custody status doesn't matter at all. It's really that it doesn't mean because she's in custody, she's guilty of something is really what I'm trying to get at. So, and then I included about the defendant and Ms. Hernan. The jury heard a statement that they were felons. And I included language about that. So because these are cautionary, I think it's important that the defense actually request them or agree. And what I've added, really it come after the first two lines, which are separated by paragraphs, but the first two lines make up the standard defendant elects not to testify. And then it's the third and fourth paragraphs that I've added. So go ahead.
Okay, thank you. I like everything that the court has written in here, and we do want it. I'm just not certain that paragraphs 3 and 4 should be under the heading of defendant elects not to testify. That's my only concern about it, because I really.
That's why I had the question.
Yes, right. And I prefer that the defendant elects not to testify just be its own, and then maybe since all of these have a heading, I don't know, maybe just could be a separate. Not sure what we would call it.
That's kind of where I was at yesterday. But all right, what's the state's position on this language?
So I don't have any strong objections. I personally would do away with paragraph 4 and not highlight one statement in a 3-week trial revolving around Ms. Hernan, but obviously more importantly, Ms. Kurczewski being a felon. But if the defense wants that in, I don't object to it. I just personally think it highlights for the jury one statement, again, in voluminous testimony. As far as putting it somewhere separately, I think you could. I think later on we'll see a cautionary instruction about referencing jurors by their number. We could simply call this a cautionary instruction as well and separate it that way.
So I don't disagree with that. That could be a good title for it. I think it flows well. So I would ask that it remain in this location. You do defendant elects not to testify, and then maybe we move to a cautionary instruction because they do relate to some extent, just a little bit. But I agree with the title of cautionary instruction.
Any objection to that, Attorney Sitzberger, that I just put that heading cautionary instruction right after defendant elects not to testify, meaning that section, leave it there with the language because the defense has approved of it and you're not taking a strong position.
That's fine with the state.
Okay, then we'll do that. All right.
It's just fine. I'm just separating it out and calling it a cautionary instruction.
Yep. All right, exhibits, objections of counsel, evidence received over objection is, of course, very standard. But any objection to the verbiage?
Okay.
No, it's standard. Thank you.
Same thing, improper questions, stricken testimony, weight of evidence, remarks of counsel, those are all standard. Any objections to those on pages 18 and 19?
Your Honor.
No, Your Honor.
All right, the precautionary statement on numbered jury. Does anyone want that in? I expressed this to the jury, of course, at the beginning of voir dire. I included it just in case you all thought it was important from the state.
I don't want it in personally.
I agree with that. I don't want it in.
Don't want it in? Okay, then by agreement, I'll take it out. Jurors' knowledge, expert testimony general, and expert testimony hypothetical questions and closing arguments of counsel are all standard. Any objection to those from the state,
No.
from the defense?
No objection.
The closing instruction standard. Of course, I drafted verdicts based on that reckless. That was by no means in any way suggesting that I agree it should be in or not. I just wanted to have it there just in case, because it takes a little bit of time to draft those.
So it's to the verdicts. The only suggestion on the forms of verdict would be that you read the not guilty option first before the guilty.
So if there is a lesser included, the pattern tells you to go through the guilties and then the not guilty, and then they actually answer it on a form. I'm not sure we had sent over what the verdict forms look like, but there's a line and they have to check it off, and there's a very specific instruction. If it's a standalone, I always put the not guilty on top of the guilty in the packet when it goes back to the jury. As you can see, counts 2 and 3 really read through that. We'll kind of hold off on verdict for count 1 at the moment because we obviously need to decide some of these other issues first. But what about the verdicts for counts 2 and 3 and the special questions?
The only change I would request is that instead of referring to it as intentional transfer of movable property, we just call it theft throughout. I think that's the verbiage we've used this entire trial. And though an element tailored to that theft is the transfer of movable property, I think the actual crime that's been referred to a number of times is theft.
What's the defense position?
I think it's correct as you've written it.
I was looking back over at the theft jury instructions, and they do. So the charging language says did intentionally transfer movable property of Lynn Hernan in count 2, and then the estate of Lynn Hernan in count 3, and then the values that have been alleged. Because the statute requires that there be a selection. There's multiple ways to violate the theft statute, but the crime itself is theft. And then it says statutory definition of the crime, theft as defined in. So I believe that that is more appropriate to include or just to reference it as theft. I think it would be also accurate, though, to say theft of movable property, since that's part of the specific allegation. So I'll take out the intentional transfer of and just put theft of movable property. And then the first one having a value that exceeds $100,000, and then theft in the second, in count 3, having a value greater than 10,000 but does not exceed 100,000 is charged in count 3. Any further discussion on that from the state,
No, thank you.
from the defense?
It looks, I guess if that's how the court wants to do it, that's no strong objection to that.
Okay, thank you. The bottom part of page 23, the last paragraph, is the standard verbiage about determining guilty or not guilty for each of the offenses charged, making a separate finding, and that your verdict for one must not affect your verdict on any other count. Any objection to that from the defense,
No.
from the state?
No.
And then it has the standard verbiage on unanimous verdict and selection of presiding juror and instruction after verdict. Any issues with those from the state,
No, Your Honor.
from the defense?
No, thank you.
All right. Then just moving on, some of the things that I included is anyone requesting 201 opinion of a non-expert, and if so, on what topic?
The state is not requesting it specifically because I think it would involve many witnesses and declaring what their opinion testimony was. And I think it would be distracting and confusing to the jury to go through all the witnesses.
Attorney Kugler?
No, we don't. We're not asking for it.
All right, 201 will not be included. And then I'm not going to go through the assisted suicide just yet, just pointing out 520 is the Allen instruction just in case it's needed. I just wanted you to have the verbiage. And there's some suggested form for polling the jury so that you all would have that in the event that is requested. I typically don't follow that verbatim when there's multiple counts and I sort of combine them together, but at least you have the general idea. I'm not going to go through those with specificity, just there for reference later on, should we need to include those, okay? So let's now turn to the defense request for the assisted suicide instruction and whether it is a lesser included that this court can consider. Either is it a lesser included, or even if I assume that it is it appropriate in this case? So since it is the request from the defense, I'll turn to the defense first.
Yes, thank you. We are asking the court instruct on assisted suicide. There is, so first of all, we do feel it is a lesser included offense because it falls in the 940 chapter. And that is all of the homicide crimes. And we've outlined our position in the motion that we filed. The Court of Appeals hasn't directly answered the question because they were able to dodge it a couple times. We've seen it.
Exactly my word.
Oh, we've seen
They
it.
dodged it.
They could have dodged it a couple times. We've seen it come up saying there wasn't a colorable argument that the jury could find the defendant not guilty of first degree intentional, but guilty of the assisted suicide. I think it's absolutely the case that it's a lesser included based on it being part of Chapter 940, combined with the State versus Chapman case that we cite in our motion that held that all forms of homicide are a lesser included of first degree intentional. And the statute in the cases say that the difference in elements doesn't matter when we're dealing with lesser includeds of first degree intentional homicide, unlike other crimes, because it's specifically carved out in the statute as a special category.
So let me just ask some questions about that.
Sure.
And is it truly a homicide? Is it just by virtue of, 939.66 sub 2, I believe, is it a homicide? When you look at the elements of assisted suicide, the distinguishing, I think, factor that I need to consider is that assisted, or part of the elements of assisted suicide is that the deceased commit suicide and have the intent to commit suicide, and that the defendant in this case would have needed to provide assistance with the intent that the victim take her own life. Whereas when you look at homicide charges, it's always the life of another. There's a third party actor, if you will, right? It's not the victim whose intent matters in any of the homicide allegations. And even though it's in 940, it's really under the heading dealing with life. And I know we're not bound by headings per se when looking at the statutes. 940 is broader. It's crimes against life and bodily security. And while it's, again, under that heading of life, shortly before the subchapter on bodily security, there are things in there that are broader than or different than homicide. But so any case law, I know Wisconsin doesn't have anything definitive, right? As you said, the Court of Appeals really dodged it. Our Supreme Court hasn't answered it, but any other persuasive case law you can point me to, or any other argument on, is this truly a homicide because of those distinguishing, what I would call, factors?
I appreciate that, and I don't have, I mean, we've searched really, and I don't find anything that is right on point. But like the court pointed out, Chapter 940 is a large chapter, starting with 940.01 and going all the way to 940.49. But assisting suicide is under the life subchapter Roman numeral I, which suggests that that it is considered in the category of homicides. It's mutilating a corpse, assisting suicide, abortion, partial birth abortion.
Mutilating a corpse would never be a lesser included, though, of a homicide. And I think that's pretty clear. And so just to simply say that it's in that subchapter, I don't think is persuasive or definitive.
Well, and to your other point, of course, during the trial, Dr. Thomas testified that it could have been a suicide. So as to the question about whether there's evidence in this record that the defendant provided assistance to Ms. Hernan and that she had an intent to take her own life, there is evidence in the record taken in the light favorable to the.
But what's the evidence that your client had the intent to assist Lynn? When her own, I mean, obviously she didn't testify. We had a lot of her statements come in. And the one that comes to mind the most is, I didn't think it was going to kill her, that she repeatedly says to detectives during her interview.
Right, but it just depends on which statement of Ms. Kurczewski you pay attention to. She's gave many statements during her interviews. And of course, she did indicate that at one point she knew that Lynn was suicidal. And
I understand what you're saying, but I think that goes to the intent of the victim. And the real issue is there any evidence? I'm kind of jumping to the second prong of the inquiry, though, that even if I assume assisted suicide is a lesser included, is it appropriate on the record before the court, because of the statements made by your client, that she never thought this would kill her? She got sick in the past.
Well, you can't pick one of Jessy's statements and take that one alone and not consider that there's a variety of statements.
Well, like what?
With the evidence in her statements is that she gave her a bottle of water and that she put Visine in it.
Who put Visine?
The Lynn. That Lynn put Visine in a bottle of water and Jessy handed her the bottle of water.
But Jessy was very clear. She never saw her do it, other than in the past putting herself 2 drops in. She was stating that based upon Visine bottles that she reported were in the garbage that she threw out 3 days prior.
My recollection is there's one of the statements where Jessy said that she gave her a bottle of water that she believed had Visine in it. And that, yes, Lynn had put the Visine in days earlier.
And I think there was some other testimony through the interviews that she could tell it was different because there was some oily substance.
And not only
So,
that,
but I'm going to still press you on this, though.
could I
But
reference?
knowing that it was in there, even believing that the victim's mental state was at issue and she was, depressed or frustrated with her medical condition, what can you point me to that would show that and this is the element 3 of the assisted suicide statute or element, the defendant gave assistance to the victim with intent that the victim take her own life, meaning that the defendant had the mental purpose that Lynn Hernan committed suicide or that the defendant was aware that her conduct was practically certain to cause Lynn Hernan to commit suicide.
Well, it would be an ongoing, well, first of all, a couple points. One, I want to remind the court about the state's own presentation where investigators believe that Lynn's, in their interviews of Jessy, time and time again, I think I made note to myself of how many times they suggested that this was an assisted suicide, and they believe that Jessy assisted her, that Lynn wanted to kill herself and that Jessy wanted to assist her. So that was, the jury heard that time and time again. There must be 6 references to that.
That doesn't mean that's your client's state of mind. Them trying to elicit a confession out of her based on that is really not dispositive. It's her responses or lack thereof that are more dispositive on this issue. I need to look at the evidence in the light most favorable to Ms. Kurczewski, but it still brings me back to, you got to be able to articulate on this record, what is the evidence to support element 3 and thus make it appropriate, even if I assume, without deciding the first question, but just assuming for purposes of this discussion that assisted suicide is a lesser included, I still have to determine whether it's appropriate on the record before me. And there has to be some evidence or reasonable inferences from the evidence, right? That Ms. Kurczewski gave assistance to Lynn Hernan with intent that Lynn Hernan take her own life.
So a couple of things, again, I want to mention is that besides the investigator making those comments to Ms. Kurczewski, how about her response, Judge, where she says, well, either way, then I'm going away for a long time. So it's like a resignation that they were correct. That's how I interpreted that interview when I saw it and watched it and saw it replayed. So there's that. Also, I don't want to lose sight of the fact that another allegation here and the suggestion that's been made during the presentation of the state's case was that the state say or suggest that Jessy bought guns for Ms. Kurczewski, or for Ms. Hernan. And so again, going back also to the first part of what the court was asking about, like in any of the homicides, the ultimate result here on an assisted suicide is it results in the death of the victim. And it requires assistance, and it plays a role in the loss of life. So just like in homicide, the consent of the victim's not a defense, but here is actually an element here.
Anything else you want me to consider before I turn to the state?
Well, I think there's evidence of suicidal ideation, and there's evidence that Jessy knew of Lynn's illness. The state of mind really can only be determined by contextual evidence. And we can't pick and choose Jessy saying one thing and Jessy saying another thing, but to look at it all, everything that was presented here.
Agreed.
Right. Okay.
And I wouldn't even dispute that on the record before me, there's evidence that would support element 1. I think you could look at Dr. Thomas, you could look at, the toxicology reports. I think I'm not worried about that one. It's really, did the defendant assist Lynn Hernan in committing suicide? And did the defendant give assistance to Lynn Hernan with intent that Lynn Hernan take her own life? It's with the intent part that I'm most concerned with. So
I think under looking at the evidence, one way the jury could look at this evidence, Judge, would be that Lynn and Jessy had a very long, almost lifetime mother-daughter relationship, a very close relationship. And so.
But how does that show that Jessy Kurczewski had the intent that Lynn Hernan commit suicide?
Well, somebody who has a lifetime relationship, a loving relationship with somebody, and they know they're sick and they don't have a desire to live any longer, because there's been testimony in this record of that is reasonable to assume, and jury could assume that somebody in a Jessy role might want to assist. It's kind of like when we were in voir dire, one juror who ended up being excused said, hey, listen, this is a complicated matter for me, because I think that if I love somebody and they want some assistance with that, I think I would probably provide it, something along those lines. And I think based upon how the evidence came in here, a jury could see Jessy and Lynn in that same light.
You would agree, though, that really the only evidence related to the intent of Miss Kurczewski would be her own statements that came in through the course of the interviews or anything she may have said to anyone else. But I understand, and when we look at intent, right, it's the facts and circumstances surrounding it, can be circumstantial, but primarily we're looking at, right? No one else can say what Ms. Kurczewski's intent was. This jury's going to have to decide that, but there has to be some evidence of that. And so, whether the victim intended to commit suicide, meaning part of element 1 and really, which is part of element 1, I agree. There's some evidence there when taken in a light most favorable to the defense. It's really the elements 2 and 3, and primarily element 3. So let me hear from the state, and I'll give you the last word on that.
Okay, I just want to, I forgot to mention to you that also there's evidence that Jessy bought Visine, that she would bought all these bottles of Visine, and there's that suggestion that she did know what the consequences of THC tetrahydrozoline were, because the state presented evidence of texts between Jessy and Scott Craig in January, before cause of death has been determined here, that showed that she had some knowledge of it because she discussed it. The drug name is the way the state brought it out, the actual name of the drug, tetrahydrozoline, and she brought it out with Scott Craig before that was even ruled as a cause of death.
All right, thank you. I'll hear from the state.
Thank you, Judge. So the analysis this court should go through is really, I think, should focus on the first prong, and that assisted suicide cannot, by definition, be a lesser included first-degree intentional homicide. I think the defense is misconstruing 939.66 sub 2 for the premise that anything under subchapter 1 of 940 is a lesser included. This court has already correctly pointed out that 940.11, mutilating or hiding a corpse, is not a lesser included of any homicide. And just as similarly, assisted suicide is not. Part of this trial has been sort of painstakingly going through the legal difference between homicide and suicide. They are very different things. So when 939.66 sub 2 talks about a less serious type of criminal homicide, it's really limiting to just those top sort of half of crimes listed in subchapter 1 of 940 that are homicides. To declare otherwise would lead to an illogical ending whereby the state, really in any homicide case, would have to prove beyond a reasonable doubt that the defendant took the life of another. But if the defendant merely brought up the fact that the victim wanted to die, the state would now have to also prove beyond a reasonable doubt that the victim killed themselves, because that's what we're dealing with here. If you allow this as a lesser included, somebody has to prove to this jury that Lynn Hernan took her own life and had the intention to do so. And that's certainly not what we've proved. And I'm certainly not making the argument that any burden shifts to the defense to prove element 1 of an assisted suicide, but thereby is the illogical nature of this argument claiming it's a lesser included. And so when we see under 939.66 sub 2 that it is not simply because it's a death, it's not a lesser included of any homicide, it's not a criminal homicide at all, to say an assisted suicide, then we have to go back to the Blockberger elements test, which is to say, is there any element of the lesser offense that would need to be proved that wouldn't otherwise have to be proved for the charge offense. And here, very clearly, there is. That's that illogical nature of now the state has to prove really both that the defendant took the life of another, or somehow make this completely 180-degree different argument that if you don't believe that, then you have to believe the victim killed herself, and we have to prove both of those things beyond reasonable doubt. It just doesn't make sense. I agree that there is no Wisconsin law on point. There's a 1996 case that's unpublished that just historically, again, as I think the court mentioned, declined to decide on prong one and went right to prong two. I did find one American Law Journal article from 1985 that sort of summarizes a number of states dealing with this. I can tell the court that their summary of their review of a number of different states dealing with this issue really led to, there is no uniform conclusion, but what a lot of states that are referenced, and then I can email it to the court and parties, but what a lot of states have even found is that they've upheld murder convictions, even in cases where a defendant and the victim entered suicide pacts together, and one was, I hate to say this, but successful in committing suicide, and the other attempt either didn't go through or was unsuccessful. That person was still convicted of murder as opposed to an assisted suicide. So again, under prong one, and I understand what Attorney Kukler was saying as to prong two, but I think it's important to remember for prong one, whether it's a lesser included just on its face, does not deal with any of the facts that came out at trial or any of the alleged conduct. It simply deals with the language of the statutes on whether something can be considered a lesser included. I don't think this court even needs to go to prong two because of the illogical situation that would be set up if we call this a lesser included and sort of the unreachable burden the state would have to face between the two. But if we do reach phase two, I would say that even the expert the defense has brought in was not able to a degree of medical certainty, call this a suicide. She was undetermined. And so she couldn't tell this jury whether it was a homicide or a suicide. So there's no evidence aside from Ms. Kurczewski's statements about Ms. Hernan, that this was in fact a suicide. It's not as though they brought somebody that said, I would have determined this is suicide. Undetermined is the best we have. So if we get to prong two, I would highlight that there's no solid evidence which the jury can go on right now to lead them to believe anything about a suicide. And I understand for lesser included, it doesn't have to be beyond a reasonable doubt. There has to be a reasonable basis. I would agree with everything the court said on the third element. But again, I don't think we have to get past prong one because this is not a lesser type of criminal homicide and it does not pass the elements test.
Attorney Kukler, anything else?
I mean, well, Ms. Kurczewski wants me to mention to the court, and it's a fact of her life that she was revoked for assisted suicide. And we did, of course, sort of quasi talk about that, although possibly not with the jury. But she was revoked for that.
It was not talked about in front of the jury, number one. And number two, the burden of proof at a revocation hearing is very different than the burden at a trial. And so that has, I understand why it's being brought up, but it has no bearing on what the court's doing today.
So first of all, yes, I would like to respond. I would indicate that I believe we're entitled to the instruction if a reasonable jury looking at the evidence in the best light for Jessy could find, not that they must find, but if they could find it. And just like we don't need to specifically identify the evidence that meets each element of a crime, if the jury could find based on some combination of the evidence, we don't need to specifically identify the facts in the record that taken together would certainly be enough. And I don't think the court is permitted to weigh those statements. Someone has to decide here on less than clear evidence. Due process requires that the jury do that, not the court. And if the jury thinks it's not fully supported, they'll come back not guilty on it. I mean, precluding that option where here there's evidence that even the state believed it was assisted suicide based on the investigator's statements, throughout the part of the investigation would be wrong. And as far as the argument on these other states, those states likely have very different statutory language. I don't know what is, the statutory language in any of the states that's being referenced by Attorney Sitzberger, but they very likely have different statutory language about lesser included. And without the context of that statutory language, there we can't really give weight to another state's practices regarding charging something as a homicide versus its own crime. And undetermined doesn't rule out suicide. It doesn't rule in a homicide. I think the statute's obscure enough that we all reasonably disagree on the meaning. And I think also the rule of lenity should apply here. Lenity should apply here. I think assisted suicide is arguably a homicide in medical examiner terminology. And I think we give the benefit of the uncertainty to the defendant, Ms. Kurczewski.
So I want to take this under advisement, given some of the information, the arguments that have been made. I've had my law clerk looking at whether any other state has done this. And similarly to Wisconsin, sometimes the direct question isn't answered because it's not appropriate in any given case. And I just want to kind of digest the arguments of the parties and formulate more of a decision that I think references the law that I need to reference. It won't be long. And I'm not even going to step off the bench right now. I want to think about this more. This is a novel issue in Wisconsin. We have no case that is directly on point. And I think both parties raise some very good arguments in terms of, for example, from the defense, whether it's a homicide charge, because if I consider it a homicide charge, it really doesn't matter what the elements are. That's pretty clear in the case law. So I need to answer that initial question is this a homicide charge? Meaning, is assisted suicide a form of homicide charge? I do not think that being in the subchapter that it is dispositive in any way, primarily for what I've pointed out already, and that is there are other offenses in that same subchapter, like mutilation of a corpse, that would never be a lesser included. And so that's not dispositive, but I want to give it a little bit more thought. I didn't have the benefit of the state's position yesterday. And so I'm just going to move on. I may very well want to think about the arguments the parties have on this theft issue as well, and the request that's there before I give a definitive answer. So let's turn to, and let me get the arguments of the parties on this special jury instruction that the defense is requesting in terms of a definition, if you will, to provide to the jury on really on what the meaning of another means, because we already have the definition of movable property in the jury instruction. It's property of another. Now, so Attorney Galaviz, the charge here in this case is that it's the estate of Lynn Hernan. And my initial thought when I read this is, if I assume that second will is valid for purposes of this discussion, and that Jessy Kurczewski is the only beneficiary, and she's convicted of homicide, she can't legally be the beneficiary. And if there's no one else, that means the laws of intestacy would apply. It doesn't mean that that Anthony Posa couldn't give, kind of undercuts your argument, basically, what I'm trying to say. So, so I just want you to think about that, and is your request even legally accurate, given how the laws of intestacy would really kick in under the scenario that you kind of dance around in this special jury instruction.
Well, if she's not convicted of count one, then my argument stands. If the jury comes back not guilty on count one.
What about this idea, though, that she has a fiduciary right? You have a fiduciary obligation as a personal representative. I mean, this is not a novel idea that personal representatives have been discharged from probate cases because of allegations of theft. This happens to be a criminal prosecution that includes that. So, I mean, you really are trying to kind of get I think, insert into the charge something that's not there. This idea that the estate can't be a victim.
Well, in count elements 2 and 3, they talk about the owner. Who's the owner of this property? You're saying the estate is, or Anthony?
I believe the estate is, but unless you can show me otherwise, I'm really concerned about the request that you've put forward, and even if and whether it even comports with the law.
Well, I don't think there is any law regarding the estate being the owner of this property in Wisconsin. I know you keep saying that the estate is, but I haven't found anything that says you're correct, that the estate is can be considered.
Well, what law do you have to suggest that someone cannot be charged with theft from an estate? Any case law in Wisconsin that says this can't be a charge as a matter of law?
Well, I don't think they can be charged in this particular statute. Maybe there's another statute that this falls under, stealing something from an estate, but I don't think this particular statute itself, a theft statute.
Why wasn't a motion to dismiss then brought at a much earlier stage in this game? I mean, I'm not saying you can't raise this now, but if that was truly the position, I think that was being taken, this should have been a motion to dismiss well before we ever had a jury trial on it. But be that as it may, the request is before me, and maybe I'll just ask the state. Does the state believe that the state can be a victim and that this charge is sufficient to go forward to the jury?
Yes, Your Honor, of course we do. Just like if a person goes into a bank and robs it, we don't try to figure out whose accounts that money was taken from. We say you robbed a bank. It can be a victim, just like a human being can be a victim. I think the entire length of this case, we've been clear that the estate of Lynn Hernan was the rightful owner at the time of these thefts. We've declared Anthony Posa a victim because he was the human entity that was set to receive some inheritance from that, and he was deprived of that because of Ms. Kurczewski's actions. But I think we've always maintained that at the time of the theft, this was a theft from the estate. That is another. And Ms. Kurczewski, certainly we talked a lot with both Mr. Nowakowski and Attorney Taylor of the fiduciary duty of a personal representative and their obligations and responsibilities for that very reason.
What is the state's position on the special jury instruction language that's been proposed by the defense?
I object to it strenuously. I think it serves to only confuse the jury. It adds elements that, quite frankly, should have been brought before the close of testimony. Because if this were to be given, obviously, I would move to reopen testimony then and call Mr. Posa back to ask more specific questions. This really requires us to prove, I would say, elements. I know this is supposed to be an addition to an element, but specifics that we were not obligated to do under the jury instruction that was agreed upon at the start of this trial. And so doing this at the close of evidence is really unfair to the state to sort of ask the jury now to decide these very specific things that I would note are based really completely on a fraudulent will that has not been adopted by the court. It's been filed, it's been received, but it has not been adopted by Judge Maxwell in the probate case. So it is not binding by any means, and this request only serves to confuse the jury as to count 3.
Judge, if I may
Go
respond.
ahead.
Regarding his tax scenario, there is a statute for bank robbery. It's under 94381 from a financial institution. So that's where you would go for his scenario when you rob a bank. This should have been charged under another statute, theft from an estate. Where does that fall? They always argued that Anthony Poza was the person in count number 3. When I asked them, who's the victim in count number 3, and I was told Anthony Poza. And my position was, well, it's still open. So technically, he's a potential owner of this property.
I think we're confusing though, and I'm just going to jump in right here about what the obligations of the state are under Chapter 950 versus what we have for purposes of this trial and the elements of the offense. So I'm not going to add to the statute when I have no legal authority to do that. My job is to apply the law, interpret the law, not to recreate the law, which is what I believe you're asking me to do with the proffered language. I understand what you're asking me, but I'm not going to do it. The issues related to whether an estate can be a victim for purposes of the theft statute and can fully be raised on appeal if need be. You certainly can. This wouldn't preclude Ms. Kurczewski from raising any of this on appeal, and I think might be the more appropriate, or motions after verdict, if that's in fact what happens and there is a conviction. But I'm not finding support to insert this legal interest to property in terms of the elements. And where you want me to put this in, as was stated previously, is the under element 1, where it says the defendant intentionally transferred movable property of another between October 4 of 2018 and July 9 of 2019. It defines intentional, it defines movable property. I know right here it says the owner of the property. Perhaps we should instruct the jury the estate, or just leave it as is, because it was what was agreed to at the beginning, and we'll have to address any questions that come up later on. But it's my belief and position that the theft statute doesn't limit the state from including the estate as the owner and thus this charge. But I'm not going to insert this language that you have suggested, because it frankly is confusing. I believe it adds an element that's not presently in the standard jury instruction, and would require the state to prove something that is not a legal part of the statute, or meaning it's not part of the statutory violation. Unless you have some case law that says the estate can't be a victim and that it's just some glaring hole in our statutes, I'm going to include the language that's there without any further definition, and just simply take a wait and see approach if the jury asks any questions about that. I'll let you make any further record that you want on this. Anything
I don't
else?
want any of the other elements changed as far as the way they presently exist. So I'll keep it as it is, Judge.
All right. Anything else from the state?
Not on this issue.
Okay. So that will remain as is without any. All right. Other than the assisted suicide and then perhaps maybe the reckless homicide lesser included. Any other issues with the jury instructions I need to take up? Any requests for other additions or subtractions or edits from the state?
Nothing new, but can I circle back to the assisted suicide for one point I forgot that I thought of when the court was making its comments?
Hold on to that for 1 second. Just let me ask the same question to the defense. Any other edits, subtractions, or additions the defense is requesting?
No, but for the issue that was just raised on the count 3 requested instruction by the defense, I want the record to be clear that we're not agreeing to the standard instruction. We stand by our request for the special jury instruction. We understand that the court is probably giving the standard one, but I want to make sure the record's clear. We're not agreeing to it.
All right. I think I took the agreement as understanding the court's ruling, the language as is, you're not requesting any additional changes.
Yes.
Understood. But I think that's good to clarify that for the record. All right, then you can go back to the assisted suicide instruction, Attorney Sisberger.
Judge, thank you. And it was the court's comment of sometimes the actual issue is not in the case law, but there's sort of clues to it that made me realize that I did do some research along those lines. There are cases where appellate or Supreme Courts in Wisconsin have very clearly differentiated homicide crimes to that of assisted suicide. One such example I found was State v. Gant, G-A-N-T. That's a 2015 WIAPP 83, specifically in paragraph 13. The general nature is talking about seizing electronics, but very clearly the Court of Appeals differentiates between homicides as a general class and assisted suicide. And so I thought that might be helpful to the court in reaching its decision.
All right, then I know my clerk was able to look at some other jurisdictions, but I want to, before I even mention them, they might not even be cases I can mention. I don't know if they have a similar rule in these states about unpublished and when, and if it can be cited even for persuasive by the heading, it might not be. I know we were looking at some Texas case law, Mississippi case law. Looks like the Supreme Court of Mississippi I believe that's published, so I'll give you that. I haven't read through it yet, but Mississippi versus Williams. 53 Southern, so SO period 3rd, 734, 2010 case.
I'm sorry, can you go with that one more?
I sure can.
Thank you.
Williams v. State, 53 Southern 3rd, 734 from 2010, the Supreme Court of Mississippi. It looked like one of these suicide pact cases.
Thank you. Good, I'm sorry, one final thought on that, and not that this is controlling to this court at all, but I am familiar with a Milwaukee County case that 3 days ago decided this same issue in a case actually Attorney Cotton was on, where they denied giving the assisted suicide as a lesser included. For whatever persuasive value this court finds in that, it was Judge Wagner in Milwaukee County.
I'm intimately familiar with that case, and this is something to do with a gentleman convicted now of using a rat trap to kill a female friend of his. Is nothing on the least bit similar to this.
But an assisted suicide jury instruction was requested
Yes.
and not given.
Yes, because there was no evidence of assisted suicide in the record.
That's not true. It was because it was found not to be a lesser included offense.
All right, well, I do know that sometimes the statutes or the case law talks about lesser offenses being different than lesser included offenses. So I'm going to look at that as well. I'm just going to take some time to review this since it's 11:26. I'll just break and we'll come back at 2:00 for a decision on this, okay?
Thank you.
Thank you.
Did you say 2:00?
2:00, we're in recess.
We'll be back.
Okay, 2:00. Let's see. That would be 1:00 for me. So that's 2.5 hours. Let's go ahead and take a break, and I'll start a new stream for the afternoon session, because 2.5 hours, that's quite a while. So we'll see you back in 2.5 hours, and this has actually been pretty interesting to listen to the arguments back and forth, revealing the strategy. So we'll see you soon. Okay, bye-bye.